What is a Miller Act notice? A Miller Act notice is used instead of a construction lien to seek payment for your work on a federal construction project. Examples of federal construction projects include the U.S. Post Office, federal courthouse, or VA hospital. The federal government will not allow its property to be liened. So instead, suppliers or subcontractors on federal construction projects can demand their payment rights under the Miller Act. Are all federal projects bonded? The Miller Act stipulates that before any contract of more than $100,000 is awarded on a federal project, the prime contractor must post a bond to protect subcontractors and material suppliers from non-payment. If you're supplying materials or labor to the project, you are entitled to get a copy of the Miller Act bond. It's important to make a formal request for this, as the information may be necessary for when you're filing your Miller Act claim. By filing a Miller Act claim, you obligate the bonding company holding the Miller Act bond to pay your claim directly. When do you send a Miller Act notice? You only have 90 days from last furnishing labor and/or material to send your Miller Act notice. There is no preliminary notice requirement before you send your Miller Act notice. However, best business practices is to send a preliminary notice at the beginning of the project. Who has rights under the Miller Act notice? You can only send a Miller Act notice if you are a supplier, subcontractor, or a sub-subcontractor. Third-tier or more remote subcontractors will not have any rights under the Miller Act notice. And suppliers to suppliers will not be covered under the Miller Act notice. Prime contractors cannot make a claim under the Miller Act notice. Instead, they must bring a contract claim lawsuit against the government. We hope you enjoyed this video. SunRay helps thousands of subcontractors and suppliers secure their lien and bond claim rights. Let SunRay help you get paid. Have a sunny day.